Hello everyone, this is the video of Legal Studies, class 12, unit 2nd, and the topic is law of property, and the subtopic of law of property that we are going to discuss in this video is lease. So, in this video we will be discussing about the concept of lease, rights and liabilities of the lessor, rights and liabilities of lessee, termination of lease and case study. So, we have all these points that we are going to discuss under the heading lease. So, first let us understand what is the meaning and concept of lease. As per the section 105 of the Transfer of Property Act, a lease of immovable property is defined as the transfer of the right to enjoy such property made for a certain time in consideration of a price paid or promised. So, I believe now you can appreciate such kind of language, that is just transferring the ownership temporarily for the fixed period of time on certain price that is either paid or promised to be paid. The second point, lessor is the person who lets out the property for lease or transferor, means the owner is known as lessor who is leasing out his property. Lessee is the person to whom the property is leased or the transferee. So, lessee is the person who is taking the property on rent. He is also known as transferee and lessor is known as also transferor. The lessee can also sublet the lease, and the relation between the lessee and the sublessee will be that of lessor and lessee. So, what this point is saying basically, suppose you have taken certain property on lease and after that with the consent of your owner, keep in mind, not on your own, rather with the consent of your owner or the real owner of that property, you again leasing out that property to someone else. So, in that condition, you supposed to be lessor now because okay, you are temporarily owner of that property, but you are the owner of that property and you are leasing out someone else. So, he is supposed to be lessee and you are lessor, but the real owner is of course someone else. So, that is the concept of sublet. Now, the next point is the consideration may be a fixed amount or a share of crops or serving of any other thing to be rendered periodically or otherwise. Though the second clause of this sentence saying about the crops or saving of any other things, so since this law is made, as you can see, that 1882, so at that time these were the mode of paying the rent. It may be money, at that point of time money is supposed to be something like fantasy for all those people, or not fantasy, that is hypothetical, because they had hardly money to pay as a rent. But these days it is largely money, that is cash money. Now, the next point is lease may be oral or in writing. So, it can be both. However, if the lease is of 1 year or above, then it must be in writing and must be registered. So, if you are making a lease or agreement for a lease for less than 1 year, then there is not essentially required to make a written document or registry. But if it is more than a year, then it is essential. However, if it is for 6 months or 8 months, it is not like that you cannot make. Even in that condition, you can make written agreement, but that is essentially not required. Orally, it is as valid as written one. The next point is lease for lesser period may be oral or in writing, as we have discussed. Registration is optional for such period. Delivery of possession is necessary in both the circumstances. Means what? Whether it is written or oral, in both the condition, taking out the possession of the leased property, that is essential. Until you take the possession, there is no meaning of lease. Now, the next point is what are the rights and liabilities of the lessor? You know who is lessor? The owner. The lessor should disclose any material or latent defects in the property leased. So, it is liability or duties basically of the lessor to tell the lessee about the fact or the reality of that property if there is any defect in that property. The lessor must put the lessee in possession of the property. Possession, as we have discussed, that is essentially required, otherwise no meaning. The lessor shall let out the property for lease to the lessee and make sure the lessee enjoys the property without any interruption upon payment of money. So, if you have taken certain property on lease, then it is the duty of lessor to check it out that lessee has all those basic requirements and the things that is essentially required to enjoy that property. And instead or against that, he is getting the payment. Now, the next point is, what are the rights and liabilities of the lessee? If any addition is made to the lease property during the leased period, then the addition can be comprised in the lease. So, this point is saying that if you want to add certain things in the lease, so that has to be incorporated in the agreement in the beginning itself. It is not like that you just given certain terms and conditions in the beginning and later on you are putting some additional circumstances or terms and conditions that may be possible or not, may be acceptable or not. So, lessee is not supposed to be accepting any terms and condition in the middle of the lease. The next point is, if any part of the lease property is destroyed or made unfit by flood, fire, etc., then the lease shall be voidable by the lessee. The lessee gets a right to accept or reject depending on his wish. Understand it with an example that if you have taken a property on rent and that property got damaged because of flood or fire or something like that, over which you have no control. So, it is the disaster of such in nature that you don't have any control on that. In this condition, you have the right to reject that lease or to terminate that lease or to accept or to continue that. So, it is your right, and whatever the damages that is done, it is the owner or lessor who is responsible for that, who will bear that damages, not the lessee. If the lessor fails to make repairs to the leased property, the lessee may make the repairs himself and recover the amount for the repairs from the lessor. Simple point, I believe you must understood that. Suppose if you are a renter and you did some kind of work like painting and something like that, then you can demand that amount from your lessor that you added certain value in that property. So, you must be paid that amount. Next point is, at the time of completion of the lease, the lessee should hand over the property to the lessor in the state in which it was received. So, being a lessee, it is your duty to maintain the original condition of that property. So, if you do not supposed to be making certain sort of damages and anything to that property, and if you did that, then it is your duty to correct that. So, it will be expended or it will be your money from which that will be corrected or repaired basically. The next point is, the lessee may transfer rent or sublet the leased property with the consent of the lessor. We have discussed this point, that is subletting. So, if your owner allowing you to sublet that property, then you can. Next point is, disclose to the lessor any fact that lies in the property that will increase the value of the property. Again, being a renter or lessee, it is your duty to let your owner know if there is some value addition to that property. Otherwise, it is a fraudulent act. Next point is, the lessee should pay rent at a proper time and place as specified by the lessor. Simple point. Next one is, the lessee is bound to keep the leased property in good condition. We have discussed this. When he is in possession of the property, so it is your duty to maintain the original condition of that property. When notice of any defect is given to the lessee, he is bound to rectify it within period of 3 months. So if you come to know with this such notice about the defect of that property, you need to rectify that in given period of time, that is usually 3 months. The lessee may use the property and its products and must not do anything that is destructive to the property. So you are allowed to enjoy that property, but you are not allowed to misuse that property. That may damage that property. The next point is, the lessee should not erect any permanent structure in the property without the consent of the lessor. So if you want to just construct something based on your convenience, then without the consent of the owner or lessor you cannot do that. Only after getting the consent or permission you can do that. Now the next point is, what are the grounds of termination of lease? So once lease is made, then it's not like that it cannot be terminated, it can be. So let's check out what are those grounds. The first ground is completion of the fixed period. Say a lease is made for 2 years. So after 2 years automatically it is going to be terminated. The next point is on the death of lessee before the expiry of fixed period. What does it mean? That if someone made an agreement and taken some property on lease for 2 years and he died after 1 year, so even in that condition the lease will be terminated. Next point is when lessor and lessee become one, that is merger or something like that. If lessee buys the property, then of course that lease going to be terminated. The next point is when one party surrenders, usually lessee with the consent of lessor. Though it is not allowed in the middle of the fixed period, but if lessee or even lessor facing some sort of situation that in which the agreement has to be terminated, then with the consent of both the parties it can be done, and that can be done at any point in time. If both parties who are basically the parties of the agreement wish with free consent, with free will to terminate the agreement, then they can do at any point in time. There is no issue on that account. And the last point is notice to quit or to terminate the lease. So through notice, if it is mentioned in the agreement, then through notice lessor can terminate the lease. So this is all about the grounds of termination of lease, and this is all about the lease. So we have studied so many points under the lease regarding the meaning and the concept of lease, regarding the lessor and his rights and duties, regarding the lessee, his rights and duties, and now lastly we will check out one of the cases to understand this concept of lease. The name of the case is Gajadhar versus Rambhai. What happened in this case is, a person who has taken a theatre on lease, he sublet, we have discussed the concept of sublet, to third person. But what happened in this case, the owner, the real owner of that property has created the nuisance to the third party who was basically taken on lease from the lessor, and basically for the first party, that is his lessee. So it is issue of sublet, and in that condition he was just creating nuisance, but the court has given the decision in the favor of that third party, that final lessee. So this is the issue and the decision of this case. You can go through that in detail as well. So this is all about the lease. See you in next video.